everyone, and welcome to tonight's talk. I'm Nikki from the Kellogg Hubbard Library, and we're pleased to be partnering with the League of Women Voters for this series. Before we get started, I'd like to let you know that the meeting is being recorded, so please remain muted throughout the presentation to ensure the best experience for all participants. If you have any questions, please type them into the chat, and our moderator and speaker will address them. Now, I'm excited to pass it over to Lynn. Sorry? Sorry?
Why don't I start?
Oh, I'm sorry. So I'll pass it over to Lynn, who's going to introduce tonight's speaker.
Good evening. I'm Lynn Blackwell, and I'm a member of the League of Women Voters, which is dedicated to educating voters about timely issues in politics and in government. This is the second program in our series of voting rights this season. And tonight, I'd like to introduce Professor Alec Ewald, who teaches constitutional law and U.S. politics at the University of Vermont. He is also the author of a couple of books, The Way We Vote, The Local Dimensions of American Suffrage, and he's co-editor of Criminal Disenfranchisement in an International Perspective. His research has been published in many journals, including Criminology, Law and Policy, Law and Social Inquiry, Publius, the Journal of Federalism, Quality Sociology, Social Science Quarterly, the Fordham Urban Law Journal, Wisconsin Law Review, and Columbia Human Rights Law Review. It's quite a list. Professor Ewald's current research is on criminal justice, specifically on the restrictions of rights and privileges that often come once a person is entered into the system of criminal justice. So tonight he's going to talk about the history and the impact of the Voting Rights Act, including some recent landmark decisions by the U.S. Supreme Court that have limited the reach of the Voting Rights Act. So Professor Ewald, if you'd like to begin, that would be great. I will monitor the chat and any questions you have along the way. We're going to, he's going to take some breaks so we can have some interrupting questions. Let's begin.
Great. Thank you very much, Lynn and Nikki. Thank you for the introductions. It's a real honor to be here. I've long admired the League of Women Voters and been grateful to libraries in dozens of towns along the way. We were chatting a little bit before starting the session, and it's nice that we didn't have to get in our cars and drive and can do this virtually. But because we're not in a room together, which would be my preference in these kinds of events, I don't know if people are falling asleep or if people are itching to ask questions about any of the things that I say. So, and I'll reiterate this in a couple of minutes, but I want to really not just invite, but request that if you have a question, I guess the chat is a strongly preferred sort of way to do this. So put a question in the chat at any time. And I've asked Lynn to interrupt me with abandon and prejudice at any time, because that's really how I'd like to do this, as opposed to having you all start napping and lose interest. I want to say a little bit about, just quickly, about how I got into this, this being trying to understand what the right to vote is in the United States and where it comes from and how it's protected and how we actually do it. I was in graduate school and learning lots of things and sort of casting about for things that I could write about. This was in the late 90s. And I've sort of reconstructed this recently. And, I had read an article, a magazine article actually, about state laws that prevent people from voting if they have a criminal conviction, sometimes called criminal disenfranchisement. It is indeed a mouthful. Criminal disenfranchisement law, or felony disenfranchisement law, because felony is the most common threshold. And it seemed to bring a lot of the things that I really wanted to understand better and cared about: law and race and history and political thought. Um, and I wrote a big fat paper about it in graduate school. And then the election of 2000 happened, and there were two reasons why that's important to mention here. And I think a lot of my students don't know anything about this election because all of a sudden 2000 was a very long time ago. But hopefully, people here will remember part of what made Florida so difficult in 2000 was their particular policies and practices regarding people with criminal convictions and their removal from the voting lists. And we could stop and talk about that for as long as you'd like. It was a very rich and important problem and topic. But I was also somebody who I thought I understood the right to vote a little bit. It's in the national constitution, it's in national statutes, the Voting Rights Act and other statutes. It's a marker of national citizenship. But it turned out that localities really play an essential role, not just that states have different rules, but localities determine what kind of ballots we use and where they're counted and whether we can vote early and so on, and political parties, and just the complexity of the process really entranced me. So that's what I wrote about then for a while. And I actually got involved in a Voting Rights Act case out in Washington because I had written a few other things about a criminal disenfranchisement law. I was critical of those laws and I remain critical of them. I don't find the arguments for them to be persuasive at all. And I played a very minor, I was going to call it a supporting role, but I don't think I was very supportive. I think I had no impact whatsoever. But we can talk about that case if you're curious, a Voting Rights Act case out in Washington. And I'll circle back to that in a few minutes to try to explain what the Voting Rights Act has to do potentially with a state law that says you can't vote if you have a felony conviction. So here's what I want to do. Again, really honored to be invited and to try to talk about where the Voting Rights Act came from, how things have changed in the last 10 years in particular, what's happening right now. Bear with me because I actually think that the way to do this is I came up with 9 chapters, which is decent for a book. I'd rather have them be short pieces than long ones. So what I want to try to do, and again, I want to repeat my entreaty that you interrupt anytime with questions, observations, redirections, tirades, and I want to try to walk the walk on that. I'm not very good at wait times. Do we have anything yet, Lynn, that showed up? I actually don't see, I haven't played around on the Zoom here, but I don't know if I don't
No.
see any action in the chat from my vantage, but do we have anything yet?
No.
Okay, that's fine. I will stop repeating this every third sentence, but I really would strongly prefer for people to pop in questions whenever. Okay. Chapter 1, Reconstruction, really have to go back to the period right after the Civil War when the Constitution was transformed. 13th, 14th, 15th Amendments. 13, no slavery. 14th, the spectacular, magnificent Section 1 says equal protection of the laws, privileges and immunities of citizenship, due process of law. But then there are some following sections, which I'll get to in a second. And the 15th, explicitly no preventing somebody from voting on account of race. But the more important part of 13, 14, and 15 for us is the second section of 13, the fifth section of 14, and the second section of 15. So 13.2, 14.5, and 15.2. Those empower Congress. Boring language. Congress shall have power to enforce this by appropriate legislation. That's 13.2, that's 14.5, that's 15.2. It's a quiet, that transformed the Constitution as much as the magnificent language of 13.1, neither slavery, 14.1, equal protection of the laws, 15.1, no prohibiting someone from voting on account of race. 13.2, 14.5, and 15.2 gave Congress new powers. Congress had specific powers before in Article 1, but 13 says no slavery, and Congress gets to decide what it means to be enslaved and what it means to be free from slavery and to write appropriate legislation to enforce it. 14, what is equal citizenship? What is due process of law? What are the privileges and immunities of citizenship? Congress has the power to enforce this by appropriate legislation. And 15, no preventing somebody from voting on account of race. Congress has power to enforce this by appropriate legislation. In the immediate aftermath of those enactments, in 1870, 1871, for a brief shining moment, Congress did it, and the executive branch enforced those laws. The Enforcement Act, the Klan Acts, prosecutions were brought, convictions were won, people were fined, people went to jail for violating new federal laws that said you can't deprive somebody of the right to vote. There's a new federal criminal statute that says we will prosecute you for a federal crime if you do this. This is a painful chapter. It wouldn't surprise me if this August organization has already had presentations on it and will in the future. I think people know the broad outline. Congress and court collaborated for a brief period in the executive branch, but after the mid 1870s, gave up, failed, got exhausted, said, we have done enough for the Black man and we'll do no more. Those prosecutions stopped. The Supreme Court very much contributed to the failure of Reconstruction with a couple of horrific cases from that period, particularly a case called Cruikshank, which we could talk about, a case called Giles v. Harris, some other cases from that period. And that's really the first step. Reconstruction, the writing of these new amendments with these enforcement powers given to Congress, powers that were used for a brief period and then sort of fell into quiescence. The court prevented some of those prosecutions. Congress lost interest. The executive branch, put it mildly, lost interest in those prosecutions. White Northern liberals lost interest in pushing the federal government to protect Black voting rights in the South around the turn of the century and in the decades before that. So I do want to pause here again. I want to walk the walk on this. If anybody wants to talk more about Reconstruction, please do hop into the chat at any point, and Lynn will wave at me and tell me. Do we have anything yet?
I have a question.
Good.
Well, there's a couple of things. During that period, right after the Northern, or the Congress gave up, as you say, in the mid 1870s, there's a period that people often refer to as the Jim Crow South.
Yeah.
And I want you to, if you could explain what that means.
Yeah.
And how much voting rights is a part of it rather than the whole thing.
Good. Are there any other questions in the chat?
Yeah, there is one here. Hold on.
I am absolutely vividly holding your question in mind.
Okay.
But I want to do anything else. Yeah.
So what else was going on that everyone gave up? Okay. Why did everyone give up on?
Oh God.
Yeah. That's complicated.
It's one of the deepest, for me, hardest and sort of cognitive and other levels questions about US history, the failure of Reconstruction. One way to think about it for our purposes is it's just a little bit perverse, but in some of these cases, it's in arguments before the courts that if, and I'm going to use their language broadly speaking, but if the Black man has been given the ballot, their language, he should be able to protect himself. And therefore, federal enforcement mechanisms are really not necessary. We should return to the federal system that existed before the Civil War. So one is a misunderstanding, really, of the nature of inequality as it was returning in the South. One is a lack of respect for genuine equality, as I think we would define it now, a different definition of equality that said, as long as you're formally allowed to participate, any other kinds of restrictions on your participation are not the concern of the national government. There is also a belief that the pre-Civil War Constitution, under which the states completely controlled, who got to vote and how they voted, that was the proper way to do things, and that this temporary interruption should subside. So incredibly unsatisfying answer. I really recommend Eric Foner's great book about Reconstruction, probably the famous magisterial book about Reconstruction. There is a great book called The Day Freedom Died about the Cruikshank case that explains, focus on that case, of course, but explains the political context in really brutal detail. I don't like metaphors of fatigue. They seem kind of psycho historical. I don't know what it means to say the North was fatigued, but there was some, after the death and destruction of the Civil War, inability to persevere with that. So do we have anything else at this point? Because I want to jump to your question, Lynn. Do we have others?
No, I don't think so.
Okay, good. Please do keep it up. Thank you. So yeah, chapter 2, there's a great book about convict leasing called Slavery by Another Name. And Douglas Blackman suggests that we rename the Jim Crow period the era of neo-slavery, because across so much of the South, the system's really replicated in some very different forms, but replicated the intimidation function, the economic function, of course, the intense legal physical segregation function that slavery had brought about. But during that period, and really starting in the 1870s and certainly in the 1880s, and they were incredibly explicit about this. There's a famous speech by John Knox, I think in the 1890 Alabama State Constitution Convention. Resurgent former Confederate white elites in the South said, we are going to disenfranchise Black men within the limits of the new Constitution. They said, we will use violence. And remember, the word supremacy and white supremacy that was a positive term in their mouths. They used it openly. That's what they were pursuing. We will restore white supremacy in this state. We will prevent Black men from voting with violence where necessary. Again, they said this all very explicitly and clearly and proudly even. We will use literacy tests or understanding tests. We will use grandfather clauses. Could your grandfather vote? We will use property tests. We will make sure that only the qualified people can vote. And everyone knew that these tests were going to be administered in a discriminatory fashion. And so that's really the second essential chapter for us, which is that for decades after the mid 1870s, Southern states in particular had absolutely open mechanisms by which people were prevented from voting, but that were facially neutral. That's an important sort of phrase that the lawyers use. A facially neutral law is one that says you must be able to read and write in order to vote. And on its face, it does not refer to the race of the voter. It's just about the voter's qualifications. And so across the South, the white primary, only white men may vote in the Democratic Party primary here in Texas. For a long time, political parties were considered to be dinner parties. They were not part of the state. And so if they discriminated on the basis of race quite openly, that was permitted in the courts. That was true until the 1940s. So the white primary, the poll tax, the literacy test, the grandfather clause, physical intimidation, all of those things kept Black men and then Black women from voting across the South with extraordinary success. Very single digit turnout well into the 1940s and 1950s across much of the South. So that's chapter 2, I think, is one that people are familiar with. Again, Jim Crow or the era of neo-slavery, and absolutely open and transparent and effective elimination of Black voting across the South. Yeah, questions at this point before things crank up in the 1940s and 50s? Yeah.
Oh boy, this is a long one. Are you ready?
Good. Yeah.
Is that concept that if you have the right to vote, any problems you have are your own doing, the basis of the issues with systemic racism? If voting rights are restrained through systems, i.e. tests of Black Americans before they could be allowed to vote, to requirements of particular kinds of documentation to establish citizenship or residency, intimidation of people at the polls, etc., then those whose rights are restrained cannot enjoy
well said
benefits of the right to vote, but are also then blamed for their problems, poverty,
that's well said. Yep.
lack of housing.
It
So that's
is. I
more
can't say
comment.
it better. No, that was, I hope people could follow that, because that really, like, the circularity of that is perfect. It's exactly correct. It's perverse. And it really was completely dishonest, I have to say. That is that was really well said, and in the question in the chat. And so thank you for that. It's absolutely accurate observation, which is it's first telling people, well, you should protect your own rights by voting, and then simply turning away from the plain facts in front of everybody, which is that they were actually prevented from voting on account of their race, and really everyone knew it. So that's right first. And I would separate that question for me analytically. It helps to separate that, again, perverse and genuinely dishonest refusal to accept what was actually happening, which is people being prevented from voting on account of race, while nominally saying if you're allowed to vote, then you should take care of yourself. There's a separate thing that the questioner also pointed out, which is also absolutely true, which is procedures that raise the cost of voting can have discriminatory consequences. And I want to come back to that if we can a little bit later. Okay, third, I'm going to do this one a little bit quickly. It's just important for people to know about this. Before the Voting Rights Act of 1965, starting in the 1940s, but certainly in the 1950s and earlier, 1957, 1960, 1964, there really was this cycle where Congress recognized the problem of racial discrimination in voting and wrote new statutes to strengthen the national government's ability to join lawsuits and to bring lawsuits to try to fight racial discrimination in voting, identifying literacy tests as a problem, identifying the inability to register as a problem, and bringing lawsuits, litigation, following legislation, and then you recognize problems that those lawsuits bring up, write a new law in 1957, write a new law in 1960. The 1964 Civil Rights Act actually has a lot about voting rights in it. So the 1965 Voting Rights Act didn't spring, what is that expression, from the head of Zeus, or I guess it would be Zeus as played by Lyndon Johnson. There's these precursors in these earlier statutes and this earlier litigation. What Congress found is that looking around at the world and waiting for people to come in and say, I need you to bring a lawsuit because I was denied the right to vote on account of my race. Lawsuits are expensive, lawsuits are reactive, and lawsuits are slow. And most importantly, over time, what happens is that even if you win a lawsuit and you force a county or a state to stop doing this racist thing that they're doing, they just do something else. So in 1965, Congress enacts what I think most people would think is the most important statute, or at least civil rights statute in the country's history, which is the Voting Rights Act of 1965. And again, if you'll forgive me, I said I would pause after every single little chapter, but there is that third step really is litigation and legislation before the Voting Rights Act is really important. The 1965 VRA did not come out of nowhere, and that's really important for a couple of reasons. One is that the specific things that are in the VRA are the direct result of what Congress had learned from the litigation and legislation and failures and successes of the previous 10 years. So what does it do? Critical word about the 1965 VRA, it's temporary. Literacy tests are suspended for 5 years in certain places. This is the example that I want to start with because it folds everything into one. The initial VRA does not ban literacy tests, and it only suspends them in some parts of the country. Now, eventually, literacy tests would be banned permanently and nationally in future iterations of the VRA, but the initial VRA, it's such a great example because, and this is a bit of foreshadowing, in my view, unfortunately, about where we are now, but the initial VRA says literacy tests have racially discriminatory effects, and so they are temporarily suspended in parts of the country where Black voting turnout is very low, and where there's a history of the use of such tests in the past. Certain parts of the country are placed under what's called preclearance. They are told you can't change any part of your voting rights procedures. You can't switch to a different kind of ballot. Burlington, Vermont could say, we're going to play around with instant runoff voting, but Burlington, Mississippi couldn't play around with instant runoff voting if they wanted to. Under preclearance, you can't change anything about your voting rights rules or your election practices without consulting the federal government and having the approval of a federal judge or the federal Department of Justice. Federal voting registration is available in certain jurisdictions across the country. So the Voting Rights Act is this major transformation of federalism. the Congress finds that poll taxes have discriminatory racial effects and empowers people, empowers the Attorney General, I should say, to bring lawsuits against poll taxes. The Supreme Court full-throated, wholehearted, enthusiastically endorses this statute. South Carolina immediately sues to stop this horrible destruction of federalism and infringement on sovereignty. And in South Carolina versus Katzenbach, there's one line of this that I wanted to say for the group, which is that the court wrote, Congress felt itself confronted. Love that. Congress felt itself confronted. And notice what that does. Congress is the victim. It's not Congress that's setting out into the world and wreaking havoc. It's the southern states that had perpetrated an unremitting evil of racist discrimination in voting. And Congress felt itself confronted, the court said, and needed to change the way elections were understood in the United States and really transform the right to vote. There were other major decisions in that period for sure, but South Carolina v. Katzenbach, and then Katzenbach versus McClung, Katzenbach was the Attorney General, Morgan, Katzenbach versus Morgan, the other major Voting Rights Act case from 1965 and 66, that really endorsed major aspects of the Voting Rights Act and Congress's ability using 14.5 and 15.2 to transform federalism and the right to vote in the United States. So 1965 VRA, I definitely want to pause here. I don't know if people have questions, interjections, memories.
I don't see any at the moment, but could you explain how pre-clearance was implemented at that time? In other words, I believe it's Section 5
Yeah, good
says
job. Yeah.
anybody who had a history of having
Yep, it's
discriminatory.
essentially the formula that
But
Congress.
the states,
Yep.
yeah.
Sorry to interrupt.
No, no, I want you to see how those states were named.
Yep. So
at
the
all.
initial pre-clearance formula was relatively straightforward, which is essentially if you had low African-American turnout in the 1964 presidential election, and a history of the use of any test or prerequisite for voting. Future formulas would get more complicated. Congress held extensive hearings in particular before 1982's revision to the coverage formula. So again, Lynn has asked a sophisticated question. I don't know if others, it's kind of specialized language, but so coverage, again, pre-clearance, those meant the same thing. It's painful to put this in the past tense, but here we are. Congress said certain parts of the United States have a history of preventing Black people from voting, and we're basically going to supervise those parts of the country. We are freezing in place the way your current voting rules are, and you can't change them without our approval because we don't trust you. I think it's fair to say that that's what pre-clearance consisted of. Section 4 was the formula, which is handy for mnemonic memory purposes. And Section 5 described like pre-clearance itself. Like, here's how it works. You have to get the Department of Justice or a federal court's approval. I should have said, I'm particularly glad you asked about this because believe me, you're not required to memorize the sections of the Voting Rights Act, but to understand where we are right now today, it is actually important to know 2, 4, and 5. So Section 2 is, okay, I'm sitting here in my county, I'm sitting here in my state, I'm sitting here in my utility district, and they changed the rules for registration, or they closed 6 of the polling places here in my city, and they're all in the Latino section of town. I think that my county has just deprived me of the right to vote on account of race or being language minority status. That's also in the statute, by the way. Section 2 enables me to bring that lawsuit. And that is still, as we sit here in 2025, that is still a valid binding part of the VRA, Section 2. Section 2 says you can't prevent somebody from voting on account of race. I'll come back to this in a second. Section 2 just says you can't prevent somebody from voting on account of race. And if I think I've been deprived of the right to vote on account of race, I bring a lawsuit, Section 2 lawsuit, if my right to vote has been denied or diluted, which we can come back to also. Yes, I can actually see the chat. Yes, indeed.
Okay.
Illegal gerrymandering.
Yeah.
So if you can hold off on that just for a second, but this is where we are getting. So districts wind up being very much part of this, but a couple of other terms for people to know. Denial is I actually am unable to cast a vote. There's a new rule that says that I have to re-register, and this is actually a racist rule, and I bring a Section 2 case. Dilution pertains to how we are counted, how we are grouped for voting purposes because of this wacky system that we have in the United States, our unusual way of doing elections. So Section 2, you can bring a lawsuit to say I was deprived of the right to vote on account of race. Section 4 is the formula, and Section 5 is pre-clearance itself. So those are major sections of the initial Voting Rights Act. Other questions at this point besides gerrymandering? Because I'm definitely going to come back to that for sure. Is there anything else that you see, Lynn?
No, I don't see any.
Okay, good. So next, the initial Voting Rights Act, again, remember, it's temporary. It's a 5-year thing. It's a 5-year suspension of literacy tests and pre-clearance and everything. In 1970, the Congress extends it for another 5 years. In 1975, they extend it again. There are some other tweaks along the way. They actually, in 1975, they do something very interesting, which is they say, if we extend this to 1980, it's going to cause trouble because there'll be a census in 1980, and all of the states are going to be redoing their districts after the census, which is the quaint good old days when that used to be the only time that districts were redrawn. So they made it 7 years. So it was 1982. So 1975, 1982 was the subsequent reenactment or amendment of the Voting Rights Act. 1982 is a really big deal. And before I talk about that, I want to see if there's, I think, a couple things that happened in the chat.
Yeah. Well, let's see. To vote in that election, I guess she means 1980, or is this the tactic to disenfranchise again? I'm not sure what the question is there. Maybe Sherry could clarify.
Yeah, no, thank you for the question asker, but go ahead and put it in the chat again, and we can come back to this because I know people are. I'm itching to talk about the present too, but the 1982 is really important for a couple of reasons. One is that Congress revises its formula for who's covered, which jurisdictions are covered, and the other thing that's changing is that there are covered jurisdictions now across the United States by the 1980s into the 2000s. I encourage you to spend some pleasant winter day afternoon hours hopping online and finding sort of coverage maps from across the years of the United States, because it was no longer just the South. There were parts of the North where native populations, for example, were disenfranchised. And so there were a lot of different jurisdictions that were covered. But here's the most important change in 1982. And bear with me for a second, because I want to try to explain this in a couple of stages. One of the things that was happening and that the courts were really fighting over in the late 1970s and early 1980s was the following situation. City says, well, we've currently got people being elected from districts. Say we have a 10-person city council, and 2 or 3 of those people come from predominantly Black parts of the city, because 30 or 40% of the city population is African American. I think we should change to an at-large voting system here in the city. And surprise, surprise, the next year, the whole 10-person city council is white guys because they eliminated the districts. But nobody said that what they were doing was racially motivated. And not to be snarky about this, but the 1890 guys are gone and the Bull Connor folks are gone. And so now we have voting rights changes that have impact. Their effects or their impact is clearly racially discriminatory, but there's no proof of intent. And the court winds up saying, in a case called City of Mobile, you have to have intent for a Section 2 violation. If you can't show that there was discriminatory racial intent, there's no violation of Section 2 of the Voting Rights Act. Congress holds extensive hearings in 1982 and says, no, you can show a Section 2 violation by showing that the impact, by showing that the effects of the change are racially discriminatory. They're very careful about this. They say, we are not saying you have a right to racial proportional representation. They say this explicitly, But we are saying it's going to be a complicated inquiry for courts to do to decide whether a particular electoral practice has a discriminatory effect or discriminatory impact. And the Senate famously, sort of a Senate report lists the factors that a reviewing court should consider. And it really, you can think of it in terms of districts. This has become most prominent in terms of districts. But is there a history of racial block voting by the white majority race such that members of the minority race don't have an opportunity to elect one of their own? So in terms of districts, the way this plays out is there a group of sufficient population and geographically contiguous such that a district could be drawn? Is this group of people politically cohesive? This is a sociological inquiry. Actual social scientists testify in these cases. And is there a history of racist block voting by the white majority race, such again that group of people and that either the racial minority or language minority doesn't have an opportunity? So opportunity district is often what the name is for these. So it does pertain to districts, this 1982 effects test or impact test, but it also can be things about a new registration requirement, a new ballot, whatever. If you can show that the totality of the circumstances prove that the effect or the impact of this practice or policy or district is to deprive somebody of voting of the right to vote on account of race. Anything that results in a denial of the right to vote, results in a denial of the right to vote. That's the new Voting Rights Act after 1982. So it's a really big change in the Voting Rights Act. The Supreme Court endorses it in a 1986 case called Gingles. And so after 1982 and 1986, the effects test, the impact test is firmly in place. And for decades, the courts navigate it and enforce it. So that's really the next big step. I want to get to something quite different, but I want to pause there because I think we probably have a couple of questions.
Yeah, well, getting back to what Sherry wanted to know, she asked if you bring a suit, um, can you then vote in that election? I guess the upcoming election, or are you disenfranchised? And actually, is this a double disenfranchisement of all the rest of people
Yeah,
who are included in your district or whatever?
yeah, I think it would depend. I mean, if you had somebody who was formally being prevented from voting, right, it would depend if you tried to bring, again, I'm actually not a lawyer. Political scientists get to pretend that we're lawyers until it gets tough and then we stop pretending. But like this would be one of those situations where you would ask for an injunction, right? Or you would, if there was literally an election 2 months from now and you're being prevented from voting in some direct way, you'd ask a court to prevent the local or county or state government double negative. You'd ask a court to enable you to vote, right? If it was literally a case of casting a ballot. But remember, a lot of these cases involve making voting more difficult generally. They might involve somebody who's able to vote, for example, but had to spend money to do so, to buy a new form of ID or travel a particular distance or figure out where the new polling place was, right? And you could still show this polling place change across the district had a racially discriminatory effect. So it's a Section 2 violation. So for decades, remember, both these things are happening simultaneously. Covered jurisdictions are saying, we want to close a bunch of polling places. Please let us do so. And the Department of Justice is saying, no, we think that's probably not a good idea. And then in other places that are not covered, places are changing their voting procedures and people are bringing lawsuits under Section 2 and winning or losing those lawsuits. But there's a great many lawsuits across the country challenging various kinds of voting restrictions under Section 2 of the Voting Rights Act after 82. Yeah, what else do we have at this point?
Well, there was another question about the importance then of keeping track for everybody to keep track of what's happening with your local rules.
Yeah.
And I
Yeah.
think that's a good point that we're all responsible for keeping discrimination from happening.
Mhm.
Could you address like really local rules that might apply just to a county government or something? Would that
Yeah, I
be?
mean, well, I mean, with regard to which aspect? I mean, so just the need to, I was talking with someone about this recently, so it's sort of top of mind, but like, I actually wish we had automatic voter registration, for example. Just the need to register is actually quite
Mhm.
burdensome. Um, Another part of the burden of voting in the United States is a little bit of a paradox, which is that we actually have way more elections than most countries. So we elect so many different local and county and state agencies and directors that voting frequently can be very taxing to sort of keep up with, like knowing when the election is, knowing where and when you have to go to vote. Do you need to re-register? States still have very different rules about absentee voting. Do you need to have a reason to vote absentee? Are you able to vote early or not? Do you have to vote in person if you want to vote early? So those are some of the, then there's the question of like your ballot technology. Are there enough polling places so you have to wait 4 hours? ID requirements, like these are all things that can make voting more difficult, more expensive in very literal terms for people. So I don't know if that's responsive, but those are some of the things that come to mind. Any other questions for now? Because I want to
I
eager to
don't
get
think
to
so.
the.
No, I think we're all
Okay,
we're okay.
so it's tough to abbreviate this period of history, especially because it was, a few decades. But I want to talk about conservative constitutional thought as it really flourished in the 1980s and 1990s. And as I think probably everyone who's joined this discussion knows, this really is the dominant understanding of the Constitution, and that on the federal courts now, certainly in the U.S. Supreme Court and on most of the appeals courts below it. And it does actually go back to Reconstruction, and especially to the 14th Amendment and what equal protection means. And the best way to explain this is that in the 1960s, in the 1970s, when a variety of governments and universities, medical schools, law schools, business owners looked around and said, we need to bring women into this institution, we need to bring people of color into this institution, Native people, right, into this institution. Um, and Lyndon Johnson gave his famous speech about, you don't bring a man who's been shackled for centuries up to the starting line and expect the race to be fair. New laws were put in place that were race conscious, and then in some places made it a plus or gave an advantage of some kind to people who were members of historically disadvantaged groups. These were a different kind of race conscious law. Of course, we'd had a century of laws that harmed historically disadvantaged minority groups. And now we have laws that sought to help historically disadvantaged minority groups. To constitutional liberals, those are obviously different. But what emerged in the 1970s and 1980s among conservative constitutional thinkers is an increasing conviction that those kinds of laws were actually more the same than they were different, because any law that classifies us differently, treats us differently, classifies us on the basis of race, distributes benefits or burdens to an individual on the basis of that individual's race, let somebody do something or give somebody a preference for something because of their race explicitly, because the government has classified them as a member of a racial group, that's something the government should almost never be allowed to do, either never or only under the most extraordinary of circumstances. It came to be associated with the concept of color blindness, which is a line taken out of context from a famous dissent by Justice Harlan in Plessy v. Ferguson, which I'd be delighted to talk about if people want to talk about that. But colorblind conservative constitutional thought started to say and started to develop this doctrine that said we need to be really skeptical when governments explicitly say we are placing people in this electoral district because they are white, and we are placing people in this electoral district because they are black. There's a case called Shaw from North Carolina from 1993, where Sandra Day O'Connor wrote a majority opinion about this that I really recommend to people. It's very interesting, even if you disagree with O'Connor. She's really working on trying to understand the risks of balkanizing, she uses that metaphor. Again, the instructional risk here of the government telling people, I think you vote the way you vote because of your race. It's a real means and ends disagreement where she's very skeptical of drawing districts on the basis of race and really fears that it might harm the country. Shaw says you can still draw these race conscious districts. You can draw districts to try to give an opportunity. Again, that's the word. An opportunity district is purposefully drawn to give members of a racial minority or a language minority group an opportunity to elect one of their own. When it's possible to do it, you must. When you can, you must. I want to slow down because I just said a lot and I want to say this again. On one hand, the Voting Rights Act says, when you can, you must. When you can draw such a district, is there a contiguous population? Do they have shared political interests? And is there a history of racial good one, racial bloc voting by the white majority against them? Is there a group that's compact and contiguous? Do they have shared interests? And is there a history of racial bloc voting by the white majority against them? If you can, you must. If the conditions are present, you must draw such a district. But Shaw, it can't only be race. Shaw is this, frankly, really very aesthetic judgment. It's thin in terms of what exactly is the difference between a district that's permissible and one that's not. So Shaw, on one hand, is very unsatisfying because this kind of aesthetic judgment, but Shaw is really a marker. Conservative, colorblind constitutional thought says we are suspicious of drawing these kinds of districts under the Voting Rights Act. We're going to keep letting states do it because the Voting Rights Act says they must, but we're skeptical. And over the decades, that really continues to be the case. The development of this conservative, skeptical, even hostile approach, not just towards districting cases, but especially in those cases. And there's a partisan element of this too that we can talk about that's really tricky and complicated, but I just want to pause there. So again, that next big chapter is preclearance doing its thing for decades, Section 2 doing its thing, but and simultaneously parallel, conservative constitutional thought kind of maturing, developing this doctrine. We are skeptical. We think that any law that treats people differently on the basis of race should be reviewed the same. We don't accept that there is a difference between laws that are benign or that purport to be benign, as Clarence Thomas would have it, and laws that seek to harm members of historically disadvantaged groups. And I think that's really important for people to understand that conservative constitutional thought, that's what the commitment is. It's awareness of the country's racist history. It's saying that was a terrible error and we need to not do that again. In order to not do that again, we must be extremely skeptical of laws that are based on racial stereotypes and that treat people differently on the basis of race. And all the conservatives on the courts these days, again, because they're so young, they've literally grown up steeped in that ideology, right? It's been, right, since people remember probably in this group, remember Edwin Meese, remember Robert Bork, right? And of course, Rehnquist was the Chief Justice back then. And that's really even since the 1970s, but certainly 1980s, 1990s, early 2000s, right? When John Roberts was in the Reagan Justice Department. This is a very sort of principled aspect of conservative constitutional thought. So do we have questions at this point before I gallop into we're almost into the sort of contemporary period, but yeah.
Well, bringing us, following up on that, my question then is sort of, to me, fundamental. How do we separate, particularly today, what is a racial intent from partisan political behavior?
And this is a really hard question in at least two really different ways. So just a few years ago, 2025, a case called Rucho, R-U-C-H-O, the Supreme Court said drawing districts on a purely party basis is absolutely fine, and we will never find that to be a constitutional violation. So partisan gerrymandering, let it rip. Like if gerrymandering is a cuss word, then there's no such thing as partisan gerrymandering because it's just partisan districting. You can leave the door open when you're in the legislature and you're drawing a district and saying Democrats are 30% of the state. Let's make sure they have 0 of the districts. That's completely permissible. because treating people differently on the basis of being a Democrat or being a Republican is not unconstitutional. It doesn't draw any type of sort of particular constitutional scrutiny. It's not race, it's not gender, it's not age discrimination, it's not sexual orientation discrimination. Being a member of a political party is something you can change. There's nothing about that that is constitutionally suspect. And so if state legislators want to draw districts, there's no constitutional check on that process. And so I'm trying to at least a little bit address your question, Lynn, because part of where we are now is that Republican majorities are really very good at drawing these districts, and they're unapologetic and very open about the fact that Republicans are very united about this. Democrats are very, very deeply divided about doing this, about partisan gerrymandering. But Republicans in states across the country for a couple of decades have been quite effective at saying we're going to draw districts to maximize our political advantage. Where this comes into our work tonight is that one of the ways that Republicans do that is to put the most loyal Democratic voters in the smallest number of districts possible. So in so many states, those are African-American voters, despite the really significant inroads that Republicans have made in terms of African-American and Latino voters in the United States and Asian-American voters in the last 15 years. It's still the case that if you want to draw a district that puts all the Democrats in one place so that they only get one district in your state or two when they're almost half of the voters, and you see this in the northern states like Wisconsin as well as in southern and border states, you're effectively doing both. You're doing partisan gerrymandering as well as racial gerrymandering. I'd like to actually, if we could put a pin in the party question and sort of come back to it, I think that would be helpful. It's kind of endlessly difficult, but there's a couple of other big parts of this that I want to try to explain. There's a case called LULAC, League of Latin American Citizens, a kind of counterpart to the NAACP, really successful and important civil rights and civil liberties litigation organization. LULAC is 2006. John Roberts, those of you who followed his work know he likes to write these pithy, sort of epigrammatic, very quotable sentences, and they're really very good, even if you don't like them. They're quite memorable, even memorizable, maybe particularly if you happen to disagree with them. He dissents in LULAC. It's a Voting Rights Act case. He doesn't like the outcome. And talking about districts, he says, it is a sordid business, this divvying us up by race. What a thing to say. It is a sordid, dirty and cheap, right? It is a sordid business, this divvying us up by race. It really, that's 2006. That's John Roberts saying very clearly how he sees race-conscious districts. He's a very smart dude by all accounts. He's also written many longer sentences explaining how he understands equal protection and race. It is a sordid business, this divvying us up by race. That's LULAC. The next big decision has an incredibly awkward name, and I love it precisely because of the name, actually. It's the Northwest Austin Municipal Utility District Number 1, abbreviated NAMUDNO, N-A-M-U-D-N-O. And it's a great reminder that, like, the Voting Rights Act applied to utility districts. It's a Texas water district outside Austin, and it's covered under the Voting Rights Act. They say two things. The NAMUDNO, the utility district, two things. First, they say, we'd like to get out from under preclearance. It's called bailing out. We'd like to bail out from under preclearance. And their second argument, and this is, again, I'm skipping over like all the conservative appointments to the court, right? NAMUDNO's 2009. It's been a very conservative court. Remember, Shaw was 25 years before this. NAMUDNO says, we'd like to bail out from coverage. And also, we think that preclearance itself is unconstitutional. And there's a real fear in the land, I will say, in the land that I lived in, that the Voting Rights Act is going to get struck down, that all of preclearance is going to get struck down. NAMUDNO is interesting for us, and I know our time is rocketing by, and so I'm going to abbreviate this a little bit. The liberals join Roberts in NAMUDNO, letting the district bail out And it's a strategic decision for everybody. It's strategic for the liberals, because remember, the liberals are looking at the possibility of preclearance itself getting thrown out. And so they get the court to answer the narrower question, letting the utility district bail out. Phew, they breathe a sigh of relief. They've saved preclearance for another day. But Roberts is also being very strategic. And he writes into the opinion, we have serious doubts about preclearance. There's a couple of very specific, strong sentences in the opinion that say, we are leaving preclearance in place, but we have some questions about it. And he gets the liberals to vote with him in that opinion. So then a few years later, when Shelby County challenges preclearance under the Voting Rights Act, Roberts can say, you guys joined my opinion. We said a few years ago that we had questions about preclearance and Congress didn't do anything. And so we are striking down preclearance. So Shelby County 2013 strikes down the formula in Section 4. Technically, it leaves Section 5 in place, which is a bit of a, I'm sorry, it's a little bit dishonest by the court. Technically, preclearance in Section 5 survives. This is true today. But Section 4, the formula is gone. So nobody is actually covered. So we have this bizarre thing where like the shell, Section 5 is still there, saying preclearance is hypothetically possible, but nobody is actually covered anymore. We can talk more about Shelby County. There's some really profound disagreements in the court, but our time is really rocketing by, and I want to talk a little bit about where we're at right now and see if do we have any questions at this point, Lynn? Do you want to hop in with anything?
I don't think there are any more at the moment. Yeah.
Good. So, well, wait, I don't mean good. I would love questions, but so good, and then I can get to the next thing. Shelby County, I'm going to say it again. Shelby County, an earthquake, eliminating preclearance, and immediately, states and counties across the country put in place all of the requirements that people in this group have been reading about for the last 10 years. All the things we've been talking about, new photo ID requirements, especially, new restrictions on early voting, new restrictions on absentee voting, new restrictions on the number of polling places that are available in certain parts of the country. A lot of things that really have raised the price of voting for a lot of people. But Shelby County also did something else really important, which is it said explicitly, two different sentences, almost verbatim, in Shelby County, Section 2 is nationwide and permanent, and we do not address it here. We are not touching Section 2. So in effect, Shelby County says, look, we're getting rid of preclearance, but all y'all can still sue, right? Like, we're going to let Texas do whatever they want now. But if what they do deprives you of the right to vote on account of race, sue them. So that's the half full version, if you will, of Shelby County is we're getting rid of preclearance. So those states and counties can now change their voting rights rules if they want, their election procedures. But Section 2 is still valid. If they deprive you of the right to vote on account of race, you can still bring a lawsuit under Section 2 and challenge what they're doing, and we're here for that. Now, people had heard this song before and really weren't sure what that meant. But Shelby County does say Section 2 is still good law, calls it permanent a couple of times, which who knows what that means. But everyone can see the writing on the wall. And so when a case from Alabama called Merrill v. Milligan comes to the court in 2023, people are concerned again that the court is going to strike down even Section 2 of the Voting Rights Act. This is a race and district case where the state had drawn only, I think, one majority Black district and was sued, and then drew two. And it's a question about that. Something like a quarter of the population, I think, was Black, and they were trying to get away with a fraction of that being represented in an effective way in these districts. I want to respect the clock and respect people's times, but I just want to mention really quickly one fascinating piece of Milligan, and one of the wonderful things about the internet, which is otherwise the bane of my existence, is that you can Google in a second now, like oral argument in Merrill v. Milligan, or oral argument in Shelby County, or oral argument in the affirmative action cases from a couple of years ago. And 5 seconds later, you're looking at a nice, clean Courier font PDF of the court arguing with itself and with the advocates before it about any of these cases. And you can skim around and you can Control F. And sometimes they're actually really interesting. And I wanted to mention something that's happening in these cases, and in some other cases too, from the liberals on the court. It's a really fascinating part of constitutional thought today, and I wanted to share it with you because I find it really fascinating, which is liberals on the court, and this is Justice Jackson in particular in the Milligan case, saying I want to talk about Reconstruction. I want to talk about history. I want to say we should interpret these constitutional texts according to what those who wrote them and ratified them understood them to mean. You may understand that originalism to be a thing that conservatives do, because for most of our lives, us old folks, right, we heard conservatives doing that, saying, well, the founders thought this way about religion, or the founders thought this way about punishment, or the founders thought this way about gender. And all y'all liberals with the idea that the Constitution should be flexible, blah, 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 blah. One thing that's happening now in the Voting Rights Act cases is liberals saying, hold on a second, I want to talk about Reconstruction. I want to listen to the record of what the radical Republicans in the 1860s and what were they doing? What did they believe? They believed in federal power to bring about racial equality. They believed in writing race-conscious statutes that protected the right to vote by means of using federal authority. It's an extraordinary, Justice Jackson is so good. And she's like doing this little passive aggressive thing of like, I thought we looked to the history and traditions of the Constitution. History and traditions is a Clarence Thomas phrase. So liberal originalism now, a thing, as the kids say, like liberal originalism on the court in these voting rights cases, really fascinating part of how these cases are being fought out. I certainly can't say if that's why, but Section 2 survives. The Merrill v. Milligan case became Allen v. Milligan, 2023. Now, the court was doing some other big stuff in 2023, getting rid of race-conscious higher ed admissions, overturning Roe. So maybe it was too much to do in that year, but Section 2 survived. But here we are again. Case called Calais. I think they anglicized things in Louisiana at least as badly as we do here in Vermont, but it's Calais, C-A-L-L-A-I-S, Calais, everybody says. Case from Louisiana involving race and districts. It was argued last year. The court asked for it to be re-argued, and it was argued just in October again. The conservatives are very skeptical of race-conscious districting under the Voting Rights Act. They know about Shaw, they know about Gingles, they know about Milligan, they just decided 2 years ago, they know about Shelby County. When I say they know about it, they know that they would be overturning a spectacular pile of precedents to all of a sudden say that Section 2 of the Voting Rights Act is also unconstitutional to the extent that it requires race-conscious, or I should say, like explicitly separating people on the basis of their race as voters, which is how a conservative would see drawing such districts. So that's where we are, that Section 2, the use of race in drawing districts in particular, is very much under threat, very much at issue in Calais, the current case out of Louisiana, because the court explicitly asked for the case to be re-argued with that question on the table. It really hadn't been directly at issue when the case was argued the first time, and the court did something. It's not that unusual for them to say, you know what, we want to take another shot at this case. They actually do that with Brown, among other big cases. But it's unusual for them to say, you know what, we want to re-argue this case, and we actually want you to handle this huge new question that was not raised in the litigation to this point, which is whether the Voting Rights Act itself is constitutional to the extent that it requires race-conscious policymaking. And so that seemed to indicate that either a narrowing of how Section 2 works with regard to race and districts, or perhaps declaring it to be invalid, might be what the conservative court is up to now. So that is a fast talking overview in 8 or 9 chapters of how we got to where we are with the Voting Rights Act. And I'd love to talk more about this, about felony disenfranchisement, anything else we want to talk about. Thank you.
Well, that's a lot to take in.
Yeah.
I have a question about it. How are the people who believe in originalism, the conservatives who want to go back to the founders?
Yeah.
How would they respond to just why? I mean, the founders in the voting rights case would be Reconstruction amendments.
Yeah. No, good.
So can they possibly go back further and say, yeah, but before that, was there any, way of discerning that race was inappropriately to be used?
I'm not sure I understood the second part. I mean, the way these originalism, the thing I try to plug in my head is that, I use the expression framers too all the time. There's nothing wrong with it. But the way to think about originalism is is what did those who wrote and ratified, it's kind of ours or wild, what did those who wrote and ratified the relevant text understand it to mean?
Okay.
Right. So if it's something that's from 1789, then what did those who wrote and ratified that think it meant? But if you're an originalist and something was enacted in 1868, then the question is, what did those words mean then? Right. So here's Justice Jackson. Um, wait, I don't think we can vote. I understood we looked at the history and traditions of the Constitution. I drilled down to that level. It became clear to me that the framers themselves adopted the Equal Protection Clause, the 14th Amendment, and the 15th Amendment in a race conscious way. They were, in fact, trying to ensure that people who had been discriminated against, the freedmen, during the Reconstruction period, were actually brought equal to everyone else. So I looked at the report from the Joint Committee on Reconstruction. That report says so that's what like liberal originalism is literally sort of, I am reading what the race conscious,
Mhm.
aggressively pro equality, pro federal power words were of
Mhm.
the, I mean, I could go on. She's quoting somebody from the Reconstruction Congress about this. So and again, to further answer your question, some of these cases and the higher education cases from 2 years ago, SFFA, the UNC and Harvard cases, they're literally arguing in oral argument and in the opinions over whether the Reconstruction Congress was race blind or race conscious. For
Mhm.
example, over whether the word freedmen is actually a word that refers to Black people or to their formal status. It's a whole. I can barely do it with a straight face, but but yeah. So other questions about? I mean, I saw a question about we need
Yeah,
a new
yeah, there
Voting Rights
is.
Act.
Do we need a
Yeah.
new Voting Rights Act that takes into account partisanship, making voting more expensive, et cetera?
Yep, and Democrats have been trying. So the For the People Act, I think from 2019, uh, didn't get through the Senate, but was a quite spectacular list, exactly what the questioner has suggested, and more of ways to make districting nonpartisan, to make early voting easier, to make registration easier, to enable people to vote as long as they were not actually in prison, for example, nationwide, which would be very interesting. So Democrats in particular in Congress have tried to write a new Voting Rights Act and have not been able to make sufficient headway. I think the other insight of that question actually is that's actually what, I don't want to personify it too much, but what John Roberts, what Roberts and his allies in the court were doing in Shelby County was saying, like, Congress needs to write a new law. We think
Mhm.
that too much time has passed since Congress designated certain parts of the country as subject to this federal requirement. We need Congress, they're openly skeptical, even frankly contemptuous of Congress. But what they're saying is write a new law. Now, Congress, of course, can't get out of bed in the morning anymore, so it's a little bit facetious to say Congress just write a new major statute.
Mhm.
But yeah, the question is absolutely right. We certainly do need a new Voting Rights Act. Democrats have tried and came reasonably close. Could a more modest bill get a few Republican votes? Not on at the moment, but it's not out of the question. Yeah, what else?
So just to follow up on that, then in the Louisiana versus Callis case, would that be likely what they might do? Say that Section 2 is no good anymore, so you need to write a new law, which
Yeah,
would be,
boy,
to me, kind of facetious.
it is. And no, it's hard. I will say, and I don't know how this will come across. It probably is cynical, but this is the virtue of being a political scientist instead of a law professor is that you have to be actually cynical about human behavior because that's part of our job. But it's one thing to say that the coverage formula under Section 4 is outdated from 1982. It's altogether different to say this permanent nationwide thing is no longer okay. Now, Justice Kavanaugh in particular, he wrote a concurring opinion in that Milligan case where it's the same logic that the court used in the higher education case, the UNC and Harvard case, which is this is supposed to be temporary. This being, in this case, like explicitly race conscious districts, in that case, explicitly race conscious admissions practices. This was supposed to be something done temporarily as a deviation from the principles of the Constitution to try to fix a problem this can't be the way things go on forever. Again, I'm badly paraphrasing Kavanaugh. He says that very, very bluntly in the Voting Rights Act context. I mean, that's the winning answer in the higher education context, is that 25 years is up, and so it has to stop. It was actually 23 years. But so I'm not answering your question because it's really hard to imagine, right? Write a new section 2. It's what you can say, write a new formula with a straight face. But if you're invalidating section 2, you're just invalidating the Voting Rights Act. You're just invalidating the 1982 amendments. You're probably overturning Gingell's, the 1986 decision. There's a huge pile of precedents written and joined by Republican justices that you would have to either overturn or narrow out of existence. It should be, again, cynical language, but it should be harder to strike down section 2 than section 4, because they really are qualitatively different. And your question is really on point, which is, you can't even say that you're saying write a new formula the way they could say with section 4, because section 2 is not, section 2 is nationwide. Section 2 says in Burlington, Vermont, if there were a, right, et cetera. So yeah, more questions. This is great.
Sherry asks, are there areas of the country that are trying to get around party discrimination? I mean,
Yeah.
yeah.
Yeah, I mean, the party thing, this is a little bit of a switch, because again, the Voting Rights Act doesn't pertain to partisan gerrymandering in any kind of direct way, except as it overlaps with race, and it kind of conflicts and overlaps in different situations. But partisan gerrymandering thing is this, in some ways, it's a classic sign of our times, in that there's a number of issues where Republicans are simply a more unified and disciplined party, ideologically unified and disciplined in sort of behavioral ways. And Democrats are just really divided on this issue. So there really are a lot of Democrats who are deeply committed to the idea that partisan gerrymandering is terrible and that we really need nonpartisan districting procedures. And then there are Democrats who say, well, we have to fight fire with fire. And if Republicans in some states are using their majorities in state legislatures to maximize their party in the national legislature, then we're shooting ourselves in both feet if we don't do the same in the states that we control. And the survival of the republic is genuinely at stake. And if we don't use our party power in the state legislature to enable us to defend our democracy in the national legislature, what's the point of being a political party? And it becomes hyperbolic. And then there are Democrats who change their minds overnight because of, right, for actually legitimate reasons, because of things that happen in other states. So when one party is really unified and the other party is really split, it is hard. But there are some states, to answer your question, that have actually had really good success from my vantage, from my preferences, with nonpartisan. Yeah, I like competitive elections. I think they make me want to vote. I think having districts that are competitive is good for democracy. It makes us more responsive. If a small swing one way or another, because people don't like the way things are going, changes the composition of Congress, then that enables Congress to be more responsive to people's will. Whereas if the legislators pick their voters instead of vice versa, the national legislature is not going to be very responsive to the popular will, and that makes democracy more unstable. So yeah, I like nonpartisan redistricting commissions. I think they've been very successful in some places that have done it. But again, like until 20 minutes ago, California was exhibit A of like how to do a good nonpartisan districting thing. And all sorts of Democrats were like, yeah, we Democrats did this nonpartisan districting thing. And now Democrats in California are moving towards trying to be very partisan in districting to try to counteract what's happening in Texas and elsewhere. Yeah, what else? This is great.
Let's see. I don't really see anything else at the moment.
I mean, we can talk. Another thing that's related, and where I've long been a fan of the League of Women Voters, is that a few years ago, I really just hadn't done enough about voting by people with criminal convictions. And so I wanted to just do some service work, like not research, but just to go into Vermont prisons and offer to help people register to vote and request absentee ballots. And I found the League of Women Voters have been doing it for years before me.
Right.
So thank you very much. And that was an extraordinary experience, and happy to talk about that too. I went to all Vermont prisons. It was an off-year election, so interest was a little bit lower. I went to the Mississippi prison too, where about 100 men are incarcerated down there in Tutwiler, Mississippi, and that was remarkable too. And the DOC, to their credit, I will say, is really genuinely trying to enable people to vote who want to vote, and really exploring. They actually had a candidate forum in the Springfield facility last summer. A couple of political candidates came and talked. This is a really interesting issue. There's a lot of Republicans in prison in the United States. I don't mean that in a cynical or snarky way, but there's been a really widespread assumption that disenfranchisement hurts Democrats because for socioeconomic status reasons, wealth reasons, racial reasons, having been damaged by the state reasons, people assume that people who've been wrapped up with the criminal legal system are going to be Democratic voters, and it ain't necessarily so. There's been a couple of really good surveys of incarcerated people by the Marshall Project. And then I did a little bit of research recently. It's a little too early for me to talk about the results, but there's a lot of Republicans in prison, and that issue it's a little bit more of a complicated issue in terms of its partisan face than people might assume.
So following up on that, what other states actually allow
Yeah,
felons to
yeah,
vote?
good.
I
So
thought there were
Vermont,
very few.
yeah,
Vermont
no,
is
it's easy.
one.
This is it's easy to remember. So there's two states, Vermont and Maine. And then I'm going to be, again, a little snarky, sorry, but two colonially occupied non-state territories, Washington, D.C., and Puerto Rico. And by the way, I don't know, like, we really need research on voting in prisons in Puerto Rico. It's been happening for a long time. I've met some academics from Puerto Rico who assured me that this is a really thriving practice, maybe corrupt in some ways that they had heard some stories about, but incredibly important. There's no research on this. It's really important. They're US citizens, of course, they're voting. Washington, D.C. actually joined the club most recently, and they're doing some really cool work. You can go on the D.C. Board of Elections website, and they regularly post new registration numbers, including for how many people register in the correctional facilities. So Washington, D.C., so to be less snarky about it, two states and two non-states. So Washington, D.C. and Puerto Rico and Vermont and Maine, those are the only places where people can vote while they're actually incarcerated. So your right to vote is never suspended. You vote by absentee ballot in your former legal residence. So if you lived in Rutland and you're locked up in Newport, you request an absentee ballot from Rutland and you fill it out sitting in the Newport prison, put it in the mail, going back to the Rutland town clerk, Rutland city clerk, and vote that way. And that's how it's done in each of those jurisdictions. Actually, I'm not sure about Puerto Rico. That's why we need results. But then the other states are all over the map. And there's just a quick sort of correction on this, not of you, but of a general misconception. Most people with felony convictions in the United States are eligible to vote. I just wanted to mention that because there's a really serious misinformation problem. A lot of people might be disqualified from, getting a license to be a barber, but they might not. They might be unable to work as a security guard, but they might be able to do it if they can apply, show they've been successful and stay out of trouble. They might be able to vote in their state if they finish their probation or parole or whatever it is. And there's a lot of people in the public who also aren't aware that. I don't mean to say these restrictions are less severe than we think. They're often extraordinarily punitive and draconian and stupid, but they're much more kind of porous and varied than people often think. And that's definitely true with voting. There's a lot of states where as long as you're not in prison, you can vote. It's true in New York. I'm pointing across the lake. New York, as long as you're not in prison, you're eligible to vote. Good. Any other questions people have about any of this stuff?
Let me just check and see. Well, I'll read it to you.
I saw a WTF at some point, but that could have been any number of things. So
Yeah, no, I didn't think
Yeah.
that was particularly helpful.
Fair.
Lucy says she loves the League of Women Voters. Any suggestions on what practical things we can do to support the right to vote? Are there towns, counties with very low voting rates in Vermont, or we can help with events where people are given help to find out if they are in fact are registered and how to get registered if they're not?
That's a great question. I'm sure people in the group would know better than me. I don't know if there are particular towns where turnout is dramatically lower than others, or where that kind of work could be done. I'm sure town clerks would love volunteers. Volunteering in the election process is always welcome. Helping people register, just being in public places and offering to help people register to vote Voter registration drives, I think, are always welcome. Just it's a nonpartisan activity. If you're doing a voter registration drive in Vermont, it's actually a little bit easier for somebody to register if you're doing it as part of a voter registration drive. The Secretary of State's office is actually really good on these things. Yeah, town meeting turnout. That's a tough one.
Yeah.
Town meeting is a complicated thing on its own, because in every big town, I think we vote by paper ballot the next day. Yeah. Yeah. Town meeting's a tricky one. But no, that's a great, I don't know if anybody in the chat like has suggestions about like best volunteer opportunities. I'd love to know them too. The prison, again, if anybody's up for it, like there are some steps you have to take, of course, to be a volunteer to go inside. But the DOC is really quite welcoming. If you want to go and do voter registration work in Vermont correctional facilities, you can contact the DOC. Anybody wants to write to me, of course, about any of this stuff, I'm more than happy to talk. But you can contact the DOC directly and try to find out how to do that, and they're really quite welcoming.
Yes, and we also have the League of Women Voters has a whole committee that are have been working in the prisons,
Nice.
and it would be good to contact your local member
Good.
and find
Good.
out
Even better.
who to contact
Good. Yeah. Don't reinvent the
about
wheel.
that.
If you already have an organization doing it, use it. Use
Yeah,
it.
yeah, we
Beautiful.
are. Well, I just want to thank you so much. This has been incredibly thought-provoking and informative. Oh, let me just check and make sure.
Registering students.
Yeah,
Nice.
they're just thanking us.
Oh,
Yeah.
yeah. Yeah. Yeah. I
Um,
saw registering students, though. Thank you for doing that. Yeah.
yeah, yeah. Oh, we are, yes.
Yeah.
Um, and if we have any further questions, we know where to find out a real answer.
Oh, no. People,
So,
please do contact me. I have a
yeah.
ridiculous hard drive of all of these things, and I'm happy to email or talk on the phone. And again, there's a wealth of knowledge and experience in this group, and I'd love to be in touch with people. It's
Well,
such an
you've been
honor.
so
Thank you all so
helpful.
much for all your work.
Uh, and we just absolutely appreciate your coming and talking with us. And so thank you so much.
My pleasure. My pleasure.
Okay.
Really. Thank you.
Well, good night, everyone. And I think we will close the meeting at this point.
All right. Good night. Goodbye. Thank you.
Yeah, thank you.